My grandfather actually was an illegal alien who came to this country in 1916. That was the only way he could get in back then because of the Chinese exclusion laws. He went back to China twice, and the second time was in the 1930s when my father was born. And eventually, when the immigration laws were relaxed, my grandfather was able to bring our family here. And by then I had been born in Hong Kong. And so we all came to this country in 1956. My father was a cook in Chinese restaurants, and my mother was a seamstress in Chinatown garment factories. So I didn't know any lawyers growing up. I certainly never met any judges growing up. But when we were at Princeton, I majored in psychology and decided, really because I didn't know what to do with myself, to go to law school. And that's how I wound up in the law.
Was there, during that time period, was there an aha moment where it said, taking a course, political science course, common law course?
Not, there was never an aha moment when I was in college in terms of the law. But once I got to law school as a 1L, I had the aha moment. And that summer, I interned for Judge Henry Worker in the Southern District of New York and loved it, knew I had made the right decision, and decided then and there that I wanted to come back someday to be a judge in that very courthouse.
Kathy, can I flip to you? I'll just have to talk to you a little about your biography. Likewise, was there somebody in your family which was law-related that kicked you off?
No, as a matter of fact, my father was a doctor, a medical doctor, as was his father before him. They didn't have much use for lawyers, generally. But when I met Denny at Princeton, we were members of the same class. We became friends, moved to New York. I wanted a career in book publishing. But went to a few of his law classes and thought that, this was sort of interesting. Ended up applying and started at Columbia a couple of years after he started at Fordham.
In part because publishing paid so little money. It was a few $1,000s a year that it was hard to make a living in publishing.
When you were at Columbia, did your paths cross with Telford Taylor?
No, okay. No. Name is familiar, but did not cross paths.
Yeah, just from a Nuremberg perspective, he was the successor to Jackson for the subsequent Nuremberg trials, and he taught at Columbia for a while.
Yeah.
Yep.
You went into private practice. Did you also go into private practice at some point?
Yes, I started at Cadwalader, Wickersham & Taft in 1980 and became a partner in 1990 and became senior counsel at the firm earlier this year. So I'm still there.
Senior counsel? You're too young to be a senior counsel, is that right?
No. I feel it. I'm definitely of that vintage.
But it's rare to be at the same place for, what is it now, 37 years. Same law firm. Yeah. As you know, lawyers these days, they don't stay in one place.
They move quite a bit. I'm in my 40th year, but I feel like a fossil, so I get it. So from your practice of the law, Judge, you started your own practice, right?
Well, eventually, but over the years I did a lot of different things. I was at Davis, Polk and Wardwell. I was an assistant United States attorney. I was at the Vladeck firm doing labor and employment law. And then right before that, I had started my own firm and ran my own firm for about 4 years.
What was that like, hanging up your own shingle?
Great fun. It was really enjoyable being entrepreneurs, being our own bosses. The hard part was...
You together?
No. I'm looking at Kathy, but it was three of us left the U.S. Attorney's Office and started a boutique. The idea was to have a civil litigation boutique. The hard part was generating business. When you leave the U.S. Attorney's Office, you're not going to take the Postal Service with you as a client. and that was the hard part, to get the kind of sophisticated litigation that we wanted when we were only in a 3-lawyer firm. And so we did it for 3 or 4 years, and then we moved our separate ways, and that's when I went to the Vladeck firm and did labor and employment law.
Principally litigation?
All litigation, yeah. Some traditional labor law representing unions, but in a litigation context.
At the DOJ, who was the Attorney General then?
Well, I was in the Southern District in the U.S. Attorney's Office. I was hired by John Martin, who eventually was my colleague in the Southern District of New York, and I served most of the time under Rudy Giuliani.
Had he established his reputation at that time as the hard-charging?
Yeah. I mean, he was known as a hard-charging prosecutor. He already had that reputation. I served under him maybe 2.5 years, and it was great fun. Yeah.
Did you ever aspire to the judiciary? Was that something where you kind of let people know you might be interested?
Not in that way, but when I was interning for Judge Worker with 1 year of law school under my belt, I realized this was something that I wanted. I just thought it was a wonderful job right there to be in the middle of administering justice. And as an assistant United States attorney, you know, your respect for the judiciary only grows, and that experience certainly confirmed that this was something that I wanted to do.
First trial, you're sitting there with your robes just like they have it, and plaintiff defendant. You're on the other side of the bench for the first time. Was that strange?
It was strange. My first trial overall was an employment case. I picked an employment trial because at least I knew the area. But I was pretty comfortable. I had tried some cases as a lawyer. My first criminal trial turned out to be a high-profile prosecution of a New York City police officer for perjury, for lying in the grand jury. And I had been hoping for a small drug case, 2-day drug trial, and it turned out to be this case where my courtroom was packed every day, and it was quite challenging. And you know, I mentioned that John Martin had hired me into the U.S. Attorney's Office. By this time, he was on the bench, and I remember calling him and asking him for help, really, advice on how to handle the trial. And the big difference was, it wasn't a matter of knowing the law or the rules of evidence. It was how were things done in a criminal case. I didn't know. You know, picking a jury, particularly when one side is saying, in every case I've done, we've done it this way, and the other guy goes, in every case I've done it, we've done it that way. When you've never done it, you don't know which is necessarily the right way, and so that was challenging.
Yeah. I'm going to fast forward a little bit and talk about being on the trial court.
Do we want to shut the door?
Just saying, thank you. He's shutting the door.
Oh, okay.
Yep. Those lawyers out there, Phillips Lytle people talk too much. By the way, thank you so much for doing this. This is terrific that you came here to do that.
You're very welcome.
Hopefully Anna didn't twist your arm too much too.
No.
Fast forward though, one of your trials which you got a lot of international acclaim was the Madoff trial. How did you get selected and from the panel, and kind of how did you handle the media spotlight?
Yeah, well, the case was actually randomly assigned to me. You know, the cases are randomly assigned, except by the anticipated length of trial. So this was a Wheel C case. The trial was expected to take more than 2 weeks. The story is that in the wheel with our name tags, there were only 2 cards left, and one of them had my name on it, and that was the one that the magistrate judge happened to pick when he was wheeling out the case. So it was a random assignment. It was a fascinating case. Presented a number of challenges. It moved very quickly, and he pled guilty, so we actually never had a trial. And one question you ask yourself is, do you handle a high-profile case differently? And one might say, no, you should handle every case the same way. You should treat every defendant the same. The reality is you can't. For example, we moved the proceedings to the ceremonial courtroom because it holds many more people. There were so many more people who wanted to get in. We had closed circuit television so that we could pipe the proceedings to 2 overflow rooms so that more people could watch. I actually issued a press release. Why would I issue a press release? Well, we were getting so many phone calls that it was easier to issue a press release saying the sentencing will take place on this date, at this time, in this courtroom, and the following are the press procedures, etc. And so we had to do things differently. One could certainly argue about whether one should treat the defendant differently substantively. One could argue that in a high-profile case, you get more bang for your buck in terms of deterrence. On the other hand, one could also fairly argue that you shouldn't punish someone more just because they happen to be a high-profile individual. And so these were some of the challenges.
What was it like at home? Did your husband is in probably the highest profile case, certainly of that year, and you're at Cadwallader, and did the partner stop by and say, "How's your husband today?"
They don't do that.
I mean,
yes. Denny and I, of course, talk about the cases that he works on, and we sometimes look at drafts of opinions together. But very rarely do the folks at Cadwallader ask me any questions about. Although I guess there are exceptions. When the Tom Brady case, what was it, Deflategate, came along, a lot of people were stopping by then. They couldn't resist.
Did that come before you?
On appeal, I was on the panel that heard the appeal. I didn't get to write. The other 2 members of the panel were senior to me, and so there was little chance that I would have the chance to write it, but it was actually quite a lot of fun to hear the Brady appeal. We're big sports fans, and certainly I enjoy football.
I bet you did. I mean, I'm just thinking about that as a sports fan myself.
Yeah.
You're hearing a case where there's law galore, but there's personalities here that you admire and cases. And,
and just reading the record, and Paul Weiss did the investigation of whether the balls had been intentionally deflated, whether there was a cover-up. It was just fascinating reading their report and the experts' reports and the record, and really getting the inside scoop on this case that was generating so much interest. It was also fun to do the argument and then go home and then turn on ESPN and listen to reports about how the argument went in front of the Second Circuit.
You probably never thought you'd be on ESPN, did you?
Have you already been on ESPN once before, right?
Yeah, some years earlier I had a case about Anna Kournikova, and Penthouse magazine published some photographs supposedly of Anna Kournikova sunbathing topless on a public beach in Miami, and the photographs turned out to be of someone else. For some reason that person sued. That case got me on ESPN and Saturday Night Live in the same week.
So that's when our kids were finally impressed by what their father did for a living. It's like, oh, Dad's on ESPN and Saturday Night Live.
You're watching Saturday Night Live. Did you see it live?
We saw it, yeah.
So what, did they give you a heads up that you know that it was coming?
No, they didn't give me a heads up. Personally, I'm not sure how I knew, or maybe we were just watching it by accident, but they did a skit of the courtroom scene.
How'd you feel about that? I mean, you're being portrayed by SNL. I mean, some people find that great, some people don't.
Well, yeah, the judge didn't have a very big role in the skit, but it was certainly entertaining and amusing. Going back to the Madoff case, Robert De Niro did a movie, Wizard of Lies, about the Madoff case, and I did watch that. and they have 2 courtroom scenes, and with close-ups of the judge, of me. I had been hoping that they would cast someone a little younger and a little hunkier. I was thinking of Daniel Day Kim from Hawaii Five-0. Instead, there is this older, meaner guy who plays me. The words they used were mine. Of course, there's a transcript of the sentencing. Maybe the order was changed a little bit, but so that was fun.
Did you have to be? Did you find yourself being a celebrity, where people were seeking your autograph and stuff like that?
No, that hasn't happened. If we go to a conference like the National Asian Pacific American Bar Association conference, there'll be young lawyers who want to take a picture with me, that kind of a thing. But life as a judge is still pretty anonymous. Yeah.
I suspect even more so when you're in the Court of Appeals.
Absolutely.
As opposed to district court.
Yeah, you sort of become an anonymous appellate judge as opposed to the trial court, where there is much more focus on who the judge is.
Recently at the Jackson Center, we had Judge Newman there, and he was reflecting similar interview like this on what part of his judicial career did he appreciate the most. There was no question district court.
Yes.
Because he's there in the front and center rather than seeing the record. Do you find that same thing in your world?
Very much. I mean, I very much miss my old job. I loved being a trial judge. As a circuit judge, I've tried to get some trials. I've actually tried 9 cases as a circuit judge, which is a little bit unusual. Life as an appellate judge is much more staid and academic. It's a lot of reading, a little bit of writing, but I miss being in the thick of the action. As the great Judge Weinfeld put it, I miss rubbing elbows with the people. One district judge who became a circuit judge said that the difference is like the difference between the search for justice and the search for error. And I think it's much more interesting searching for justice.
Oh, interesting,
yeah.
In your world, Kathy, did you litigation? Or
I'm in litigation, yes.
I know you can't argue in front of him, but did you find yourself in that appellate process at all, in the federal court system?
Yeah, I mean, I've been in federal court many times. There have been some moments of awkwardness because of the relationship with Denny. There was one time that I went in for a pretrial conference that turned into an oral argument, and the judge started the conversation by saying, I should let everybody know that I kissed Mrs. Chin last night. And there indeed had been an event at the courthouse, and he happens to be a colleague of Denny's.
Sure.
But that's a showstopper. That can throw you off your stride when you're about to launch into your oral argument. But, other than that, it's not been an issue.
Well, I can understand how that all would happen, but my gosh, that would throw you off.
Yes.
You didn't see that one coming.
Nope.
And do you still do litigation?
Yes.
Yeah.
Yes, although I find myself more and more spending time keeping my clients out of litigation as opposed to actually going into the courtroom myself, which I sort of miss. But
Kathy's being a little bit modest. She's an accomplished appellate litigator. She's argued in the New York Court of Appeals, in the Second Circuit, in 3 of the appellate divisions. So she's done a fair amount of appellate advocacy.
So the first time you argue in front of, let's use the New York State Court of Appeals, our highest court, is there a sense of nervousness there?
Oh, absolutely.
Yeah.
I think the very first time that I argued on my own as opposed to second seating somebody was also the first time I realized that I needed reading glasses. So I looked down at my notes and realized I could not see them. So I had to wing it.
Was that in front of Judge Weinfeld?
It was, no, this was the Court of Appeals.
Oh, in the
So
Court
it
of Appeals.
was Judge Kay and all her colleagues, and she later told me that I did great. So I guess it was okay. But suddenly not being able to see your notes for a big oral argument, that's sort of daunting.
I remember going to watch when Kathy argued in front of Judge Weinfeld, the great Edward Weinfeld, and Kathy gets up and starts talking, and the first thing Judge Weinfeld does is say, "Speak up!" And so that was not a great way to start either. But it just shows you, the things back then.
I actually thought he was quite kind to me. He was encouraging. I had just watched him eviscerate the attorney before me, but he clearly was a senior partner at a law firm, and he was surrounded by associates who were feeding him notes, and he clearly didn't know anything about the case, and the judge just took him apart. And after first telling me to speak up, Judge Weinfeld asked me a couple of softball questions, and I knew they were softball questions. And he also knew that I was going to lose this one, which is why I was allowed to argue it. It's like a
well, you were like
associate.
second year associate, so it was great that she was even getting a chance to argue.
So, and he actually smiled at me. How often did Judge Weinfeld smile? So he, let me go through my paces, and that was my first oral argument. But it was a great experience.
I had a pleasure of interviewing both Chief Justice Roberts and Barrett Prettyman at the same time, because they were at Hogan Hartson, and always talked about their first experiences. And Barrett Prettyman Jr. simply said, when I got the first question asked, all I could see was the lips. Nothing was registering, whatever. And I had no knowledge of what was going on. You could just see the judges, one looking for some answer. And I couldn't do anything. It was just a complete freeze. So I suspect everybody's had that kind of story.
Yes.
I mean, it's very much like, I remember thinking, this is like moot court. First year moot court at Columbia. And my year, somebody just fainted dead away as soon as he stood up. So yes, it's daunting for sure.
Well, in your district court, did you have similar experiences, not for you personally, but where attorneys would get up there and they're just dying?
Yeah, the quality of lawyering can be uneven. It's better in the Second Circuit. It's more consistent. But even in the Second Circuit, we occasionally get a lawyer who thinks that she's summing up to a jury and gives a very different kind of an argument that just doesn't work in our more academic setting. But overall, the quality of lawyering is quite good. Yeah.
Do oral arguments make a difference?
In some cases, yes. Most of the time, I would say the oral arguments don't add that much. We hear quite a few cases. Many of the cases are relatively easy. The oral arguments don't add that much. However, there are hard cases, there are close cases, and then the oral argument is helpful. It's helpful not only for the lawyers talking to me, but it's also helpful because we are a panel of 3 judges, and in thinking about the issues, and there certainly is the ability to change our thinking, change our reasoning, change the result even. And so a good argument will certainly add a lot to the decision-making process.
You both have talked a little bit about the fact that, certainly in your case, Judge, that being as now in the Circuit Court of Appeals, you do remove yourself from the real world, the people focus. And do you find that what the two of you have done on these reenactments sort of brings it back to where you're doing reenactment of cases? There's sort of that trial process, which is in the process, and doing it in front of lawyers who are actually out there in the trenches. Is that part of the thinking?
Yes. These reenactments have been a wonderful experience. They've been very gratifying because we've had such a wonderful reaction. And it's great to go back and look at these old cases and to find the transcripts, to find the old briefs, some of the original writings, and take a look at all of these things. And many of these things are still important for today. A good cross-examination in 1944 is not that different from a good cross-examination today. And many of these legal questions are still highly relevant, as in the Korematsu case. And it's been a wonderful learning experience for us. They've been a terrific teaching tool, and our Reenactments have been done over and over again, all around the country. We've even gone international. We've done one of our reenactments in Switzerland. We did one in Honolulu, Amelia Island, Princeton, and now we're going to do one in Buffalo, New York.
I mean, these are very much a team effort. Whenever we put together a new reenactment, there are always team members who help with the basic research. So for the Asian American Bar Association of New York reenactments, it's our regular team that we've been with for like 8 or 9 years, including Anna. We did one recently for the Beginning Foundation using the Affinity Network at my firm. And at the end of the day, Denny and I get to work together, putting the pieces together and actually crafting the script. And it's fun to, on a professional level, collaborate with your spouse. We occasionally have some very professional disagreements about what a script should look like.
Creative differences.
Creative differences. But at the end of the day, I think it's better for the collaboration. We bring our own experiences to how we look at this. Obviously, having a trial judge look at the way the trial scene is being set up is extremely helpful, and it's been a great experience for both of us.
For the Jackson Center, the case which you have done and did the play on, it was Korematsu. What was it that started that process of selecting and then doing the research on Korematsu? What's the genesis?
Well, it all started when Karen Korematsu, Fred's daughter, came up to us at the Napaba convention and asked us if we would please do a reenactment focused on her father.
That was a year ago.
That was like a year ago, right? She had been to some of our reenactments before, and she was hoping that we could put together something comparable, focusing on her father. Obviously, it was a great honor to be asked by Karen Korematsu to do something like this.
And you can't say no to her.
Right, there's no way to say no. In many years ago, a team had actually looked at how to do Korematsu and had concluded that it was going to be difficult because there was not a trial transcript.
Well,
but we've done so many of these by now that we know how to make up for that kind of problem.
Yeah, when we first embarked on this process, we naturally wanted to do the Korematsu case, but there was no trial transcript. So we wound up doing the Yasui case. So when Karen asked us last year, we said yes, and the Supreme Court record contains a summary of the testimony. So we took the summary of the testimony and converted it into Q&A so that we could actually have a trial scene. And for the oral argument, there is a transcript of the Solicitor General side of the argument, because he paid for a transcript, but only of his side. Back then, the Supreme Court was not automatically transcribing or recording things. So for the Korematsu side of the argument, we had to imagine it based on some notes of observers, the briefs, and the opinions. And so it's a hybrid of an imagined argument and an actual argument from the Fahey transcript.
But by the time you get to the Quorum Novus trial, there is indeed a transcript, which we were able to get from, this was Lori Benai and
Professor
Dale.
Yeah.
Was that, of course, the attorney there, I think that kind of drove that. I know that Asian American Bar really drove that, but wasn't it Gerald Irons?
Peter Irons.
Peter Irons.
Peter Irons. Peter Irons was a professor who started the whole thing. He was doing research along with a Japanese American woman who had been in the internment camps. And they uncovered some of these documents that showed that the government had lied to the Supreme Court. And so he approached Fred Korematsu, Gordon Hirabayashi, and Minori Yasui, and they all agreed to be the petitioners. And he approached Dale Manami, a lawyer in California, and he agreed to lead an effort. And so there were 3 teams of young lawyers who worked to get the convictions set aside, and indeed they were all set aside in the 1980s. And that's part of our script.
Yeah, so for that part, we had a full transcript. It was a matter of, deciding which portions of it to use.
Yeah, and that's the hard part. You have so much great material, and you're trying to tell the story of Fred Korematsu, and you want to do it in 1 hour. And you want to do it so that it is a play, that it's theatrical and dramatic, but yet that it raises these legal issues. That's the challenge here.
Did you do the postscript where ultimately he was awarded the Medal of Freedom by the president?
Yeah, we always have a sort
We
of
have that in there.
end of the story.
Yeah.
And one of the wonderful things about the script, which was largely written by Kathy, one of the wonderful things about the presentation is that we had Karen Korematsu playing herself. We had Dale Manami come and play himself.
Mm-hmm.
We had Neil Katyal, who, when he was acting Solicitor General, posted a confession of error, admitting that the former Solicitor General, Fahey, had lied, play himself.
Wow.
It was really powerful to have these three individuals coming back and playing themselves.
And you did that in Washington?
We did in Washington at the most recent NAPABA conference.
Yeah.
And essentially Karen closes the reenactment reading from her op-ed to the New York Times. And it's very moving. I don't think there was a dry eye there. I was hiding behind my podium crying.
Yeah, I mean, one of the reasons she asked us to do it is this year is the 75th anniversary of the executive order. And she had published this op-ed in the Times, which talked about, among other things, the travel ban and the relevance of her father's case to issues generated by the travel ban. And that's what we mean by how these issues are still important and relevant today.
That's, well, I hope part of what I've talked to Anna and hopefully just plant the seed, but at some point I'd love to figure out how we work with that with the Jackson Center, Chautauqua Institution, which is a large institution which loves this theatrical type thing. So I think there's be a lot of interest.
Yeah. And Justice Jackson's dissent in the Korematsu case is just a wonderful dissent. He was such a great writer. And one of the things that struck Kathy was the loaded gun comment in the dissent, and that is something that is still quoted today.
Well, if you went to the Jackson Center right now, we did a virtual tour, you would see an exhibit on the Korematsu case, which is entitled The Loaded Gun.
Yeah.
And it has pictures of the various the camps at the time, with interviews with Fred that I did, and Karen, and also we show the movie of Civil Wrongs and Rights, which was the Eric Fournier movie, which came out literally the month before Fred Korematsu came to the Jackson Center, so great timing.
Well, next time we're up in Buffalo, we'll definitely come visit the Jackson Center.
We'd be honored, beyond belief. Do you get back up here at all? Do you come to the courthouse, federal courthouse?
You know, this is the first time I've been to Buffalo. Your first time?
Well, I remember going to Niagara Falls.
You went to Niagara
when I was
Falls.
like 12 years old,
Yeah.
but that's all I remember.
Yeah, I'm involved with space for the court, so I keep hearing about the Jackson Courthouse, and so I would love to take a tour of the Jackson Courthouse, go to the Jackson Center. So we'll have to find some time, maybe in warmer weather, to come back and visit.
Hard to plan in December, I'm telling you.
Yeah. Yes.
You got lucky this time.
We did.
Definitely.
Because I'm sure Judge Scretany, now formerly Chief Judge Scretany, we do a lot of work with them. We have programs there. In fact, our very first program on Constitution Day was Korematsu.
Huh.
So all of that. What's the next project for you folks?
That's tough.
Yeah, we just presented Korematsu a few weeks ago, and we're not sure. We've done 11 Asian American programs. we've done some others as well, with the Just the Beginning Foundation, with the Second Circuit Staff Attorney's Office. We're not sure. In terms of an Asian one, we've never done one involving Korean Americans. So we're kind of looking for a Korean American case. Another possibility are the education cases. Long before Brown versus Board of Education, you had Tate v. Hurley and Gonglum v. Rice, involving Chinese parents who wanted to send their kids to white schools and were turned away. We're looking at that possibly. So we're not sure. 2019 will be Fred Korematsu's 100th birthday. And so maybe we'll revisit our Korematsu program and do it on a broader scale. That's something you might think about for the Jackson Center in 2019.
Already it's Velcroed back here.
And as your firm is seeing from doing it now, it's great that you can involve a lot of people.
Absolutely.
So you could involve students, non-lawyers, lawyers, and give them different roles. And it's just a wonderful learning experience. We've done programs at the New York Historical Society, which is Upper West Siders who are not lawyers. We've done programs with undergraduates at Princeton, for example. And so really, I think it's something to think about. You could also pair it with the programs are 1 hour, the script, and then you could pair it with some Q&A and discussion afterwards. Perhaps get Professor Barrett to come talk about Jackson and the Korematsu case. I mean, it'd be fabulous.
It's painless CLE.
Well, that's the beauty of it. We do the CLE. We do a lot of CLEs down at the Jackson Center as well, which our firm gets involved in. And you're right, and that could turn into an easy 2-hour thing with John. And in fact, Karen was part of the CLE a couple years ago. All of that. I've taken up a lot of your time, but what's the question, or maybe if you judge, that you often get that I should have asked?
It's by this point, I've been asked so many questions about a lot of different things. I don't know what comes to mind. I would say it's been really fun working with my spouse on these projects. It just added, particularly as our kids have gotten older and we're on our own more. We spend large chunks of our summer vacation working and writing, but it's, I think we've grown as a result and learned more about each other and ourselves from this process. And so, on the one hand, it's like it's so much effort and it kind of would like to wind it down, but on the other hand, it's been so rewarding that, I don't know, maybe we'll keep doing it. We'll see.
Sounds like you have a franchise going on here, though.
Yeah, I think it's not a surprise or not a coincidence that groups are reaching out to us to ask us to do things like the Just the Beginning Foundation, and so. But it's fun and it's a good cause.
Well, I got to go back to Korematsu. Just both of you having written it and now performed. Were there any surprises when you did your research? You have sort of a preconceived notion of the Korematsu case. You have, the kind of the storyline, but was in the research saying, I didn't know that.
I think for me, some of the personal story, because when you study the case in law school, you're talking about these great constitutional issues, and you don't realize that behind every case there's a real person, a real story. And meeting Karen Korematsu and spending time with her, and frankly watching her emotional reaction at our presentation, I think all of that is somewhat of a surprise, a nice surprise. And also in the course of learning and researching and studying these things about the impact on people's lives. I mean, I remember, we did one on Hart Mountain, the Hart Mountain draft resistors, and visiting Hart Mountain, and then just at the museum there, hearing a recording of someone talking about how he wasn't able to bring his dog to the internment camp, and how he had to leave his dog behind, and then the dog died. Really, the dog's heart was broken, and things like that are surprising. And then you put that as the context for the legal principles, and then Justice Jackson's words really ring even more true.
It's the personal story that you don't know as well. I mean, I think Fred would be the first to say that he was just an ordinary guy. He was not trying to make a huge civil rights declaration when he chose to stay behind. He wanted to stay with his girlfriend, but he felt that he had the right to do that as an American, and he stood up for that. And there is something admirable about that. I also wasn't aware of how much flack he took from his own family and from the Japanese American community for having done what he did. I mean, his own family members were accusing him of having been the death of his mother because it was made so difficult for her, the shame of her son doing this. I mean, as myself being a Japanese American, I understand where that attitude comes from, but it's certainly not something that I would ever have thought of when we first started working on this case. And that was part of the challenge of putting together this reenactment, is to get across somehow that Fred was not trying to be a hero, and yet he did ultimately become one.
Did Karen share with you how she finally learned about it?
Yes.
Isn't it amazing?
It's amazing, yeah.
I always thought if when we're doing a movie, that would be the starting point.
Yeah.
Mm-hmm.
Dining room table.
Yeah.
She asked. Finally, Mrs. Korematsu turns to Fred and said,
It's time.
It's time. Now's the time to talk.
Yeah. Now we had to bring that into the reenactment.
Oh, did you get that?
Yes.
Oh,
well, not the entire scene,
Well,
but yes, the basic story.
That piece of it, yeah.
Because out of everything, it's like, that was, to me, when she told the story, that was the wow moment.
Yeah, the one time we met Mr. Korematsu was when I was asked to introduce him at an all-deaf event, but that we brought our son, who was in high school then, to the event so that he'd get a chance to meet him, and that's when Karen told us a story about how she learned Oni when she was a high school student.
And that's probably what triggered the memory for her, is that this was our high school stuff.
Yeah.
Well,
Yeah.
and that's when she found out,
Yeah.
in history class. Yeah, that's the same Korematsu. Guess what?
It's amazing.
Yeah.
It's amazing. Well, you're amazing, and I really appreciate you both taking
thank
the
you.
time. And now 2019 is right here.
All right.
Keep your powder dry, because I'll probably be reaching out, if you don't mind, to see if that could all be a possibility.
It'd be
Sure.
an honor.
Yeah, that's why I put this on tape, so I'll send it to you.